Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, if my spouse is not working or is earning less than he or she has in the past, can I still receive alimony?
So especially in uncertain financial times, we field questions about the timing of a divorce and when is best for a party to make, for example, an alimony claim as an against a soon-to-be ex-spouse in the context of a divorce. And we talk about the ramifications of starting an action when the other spouse, for example, has less than stable employment circumstances or is in a situation where earnings were once very significant, but now let's say they're currently much lower. And the question is whether a spouse who would otherwise receive alimony, given all the statutory factors, could still receive an appropriate alimony award if that ex-spouse's or soon-to-be ex-spouse's income is substantially down. So that depends on the application of the statutory factors for divorce that are written in Connecticut law, especially a few key ones. In alimony, courts look to the length of the marriage, the reason for the breakdown of the marriage, the age of the parties, the health and vocational skills of the parties, the employability of each of the parties, among other things. So it's very well established by case law in Connecticut that financial awards, whether it's alimony or child support, but certainly including alimony, they may be based on earning capacity rather than actual earned income. Now, earning capacity is not an amount that a party could go out and theoretically earn, and it's not actually earned income or actual income, but rather it's an amount which a court could find that a person can reasonably be expected to earn, considering all the factors such as their vocational skills, their education, their history of earnings, their employability and age and health. It's appropriate to consider whether someone has willfully restricted his or her earning capacity to either reduce or avoid support obligations to a spouse or child support, as the case may be. One of the things that a court will look to here would be lifestyle and personal expenses as a possible measure or a basis for computing income, where the conventional methods of determining income are otherwise inadequate. So especially where the evidence shows, for example, that the reported amount of earnings is unreasonable given the expenses that a party is incurring and able to keep up with during a divorce or prior to a divorce, those are cases where a court may consider that a person is deliberately underemployed. So in the case of unemployment or deliberate unemployment, the court will certainly look to see if a person is working in a profession or position where perhaps he or she is foregoing more lucrative opportunities. Again, perhaps in an effort to reduce one's own financial responsibilities in a divorce. In those types of cases, a court may look to evidence from experts or fact witnesses with respect to an obligor's ability to earn income elsewhere. These cases are very highly fact specific, and if you have a case in which a party's income is not typical or it's not representative of what he or she has earned in the past, that's something where you should confidentially consult with an experienced Connecticut family law attorney to help you in that regard.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mylaw.com, and please visit mylaw.com for more information.